Give you an announcement.
We're down, Your Honor, to the two motions that we discussed earlier, and that is Dr. Ching's motion to compel the HIPAA and the motion to quash Dr. Ching's deposition. At this time, Dr. Ching is asking the court to compel the execution by the respondent, Ms. Delgado, in this case, of a HIPAA authorization form that I had provided to opposing counsel approximately 3 or 4 months ago. The reason for this, Your Honor, is that a very close look at page 13 of the first amended petition filed by the respondent alleges that Dr. Ching has used his position as a doctor to institutionalize Ms. Delgado unnecessarily and to institute court proceedings to take advantage of the fact that she cannot appear. Based on that, Your Honor, the respondent's mental health, stability, and overall wellness have been placed squarely at issue, but not by Dr. Ching, but by the respondent herself. We have asked for in discovery her medical, psychological, psychiatric treatment, including records sufficient to identify the treating physicians and the treating providers, and to authorize the lease of the records. The requested discovery is narrowly tailored and directly relevant to the issue raised in the respondent's pleading. The court sees in our motion and with the attached exhibits the extent that Dr. Ching went to try to get this authorization signed, and the reasons why Dr. Ching, the specific reason which is in the motion that I just argued, is also in the attempt to confer. Without getting that information, Your Honor, the respondent's discovery will be incomplete, and it prevents Dr. Ching from obtaining information essential to his defenses in this case. I would like the court to take judicial notice of the fact that there is a claim for monetary damages that Ms. Delgado has filed in this case with respect to the allegation on page 13 that I just mentioned for the court. The requested discovery is proportional and necessary in order for the court, the jury, and others to evaluate Ms. Delgado's pleadings, including the defenses of Dr. Ching. I do recognize, Your Honor, that as a general rule, medical and mental health records are generally protected. However, there is an exception to that rule, and I've cited the Texas Health and Safety Code section 241-153, number 19. The Texas law does permit broad discovery on information that is relevant to the issues pending before the court. Again, the respondent's pleading puts that squarely at issue here. And not only that, Your Honor, the production of this information will be reasonably calculated to lead to the discovery of admissible evidence. Texas Rule of Civil Procedure 192.6b grants the court's broad discretion to balance a party's privacy interests against the need for the discovery. In this case, Your Honor, you will recall that I had previously mentioned that if the court wanted, I certainly could prepare a confidentiality order respecting all of the documents that Dr. Ching hopes that this court allows the discovery of. Again, Your Honor, the respondent's refusal has required us to come to this court and seek this relief, and it does prevent Dr. Ching from obtaining information necessary for his defense. So we're asking this court to order the respondent in this case to sign a HIPAA authorization to be able to obtain her medical and mental health records.
Ms. Hicks, response?
Yes, Your Honor. I would like it noted that although this motion was filed with a certificate of conference, I was not contacted until today by opposing counsel to confer, and then demanded that I confer at noon, which I made myself available. Now, notwithstanding that, we do not have an objection. What I conferred to Ms. Figueroa and what I will again urge is that I'm just simply asking that the HIPAA be narrowly tailored, that it be tailored with regard to the exact allegations in the pleadings, which would be to the mental health care providers, subject to the time period that is alleged. So the time period alleged was originally in January of 2025 when, or January 2024, I believe, when the underlying SAPSR was filed and Dr. Ching had my client committed. So that is the first section that Ms. Figueroa pointed to with regard to the pleadings. And the second is with regard to monetary damages regarding that. So as long as that HIPAA is narrowly tailored to mental health care providers that have been listed and to the time period, we don't have a problem other than as long as there is a confidentiality order that is in place. It's just, signing a HIPAA for all that's applicable to all of her medical providers, whether it be mental or physical or whatever else, is outside the scope. And is not narrowly tailored enough to protect my client's doctor-patient privilege.
Your Honor, if I could, I think that's reasonable. What I would like to do, though, is take a look because the issues relating to the mental health of the respondent predated December 20th of 2024. And that's what necessitated the filing of that SAPSR. And I can certainly visit with Ms. Hicks tomorrow to give her a date that we're looking for. Again, it does predate December 20th of 2024.
Okay, and I'm fine with that. If you want to look at the date, I'm just, as long as it's with the time period is with regard to when he had her institutionalized, which might have been December, the preceding December 2023, I'm fine with that. I just want it narrowly tailored with that confidentiality order.
I'm happy to, Your Honor, to prepare the confidentiality order and to provide a beginning and ending date for the respondent's attorney in this case, and I'll prepare the proposed agreed order.
That should work.
So let me see if you all can crystallize this agreement. So to specify, so there is at least a general, with no specific language yet, but there is an agreement as to a confidentiality order. 1, 2, there's an agreement as to a time period. The court hasn't heard what time period that is.
And the reason for that, Your Honor, is because I have to go back. And as I mentioned, Dr. Ching filed the SAPSR on December 20th of 2024. But there may have been, and probably were, some mental health care providers or medical providers that predated December 20th. So what I'm saying is that I'll look at the records that I do have, and I'll talk to Dr. Ching, and then I'll visit with Ms. Hicks about the start date for that.
So look, I'm gonna approve the agreement, but I would rather right now you all either agree to or I will unilaterally order a specific date because I look, it's 7:01. I don't want to revisit this in a week or two when somebody says March and somebody says October. I appreciate all of the work and effort to reach an agreement, but I would, so we know that at some point before December 2024 is agreeable. Let me ask, I guess you, since this is your request, Ms. Cigarroa, how far back are you thinking you want to go?
Your Honor, if I could, I would ask Dr. Ching that question.
So
ahead.
based on what I've talked to Jasmine about and what I anticipate she plans to argue, I think we need to have her primary care doctor who was prescribing her antidepressant medicines and her.
I'm not even there yet, and there's a reason I'm working backwards. I'm starting with the easy one first, and you just went right into the difficult one. So let me rephrase this one more time. How far back do you think would be reasonable and necessary? A time period before December 2024.
I would say at a minimum, it would have to go back to, let's see, January 2022.
Absolutely not.
And the reason I say that is because she started taking antidepressants in 2022. And then I also call into question her psychiatric history.
I don't think
Give
the
me 1
judge is asking you a
second.
question, Doctor.
All right, so I've now heard a proposal, I guess, on one side, Ms. Hicks. So before December 2024 is January 2022. What say you?
Yes, Your Honor. So what is alleged in the petition and what we're dealing with is the facts that precipitated Dr. Ching having my client involuntarily committed. That happened in December of 2024. Therefore, whatever was going on with her that he's, relied on, as Ms. Segura explained, it's gonna be either December 2024 or predating that just a little bit, but definitely not. The involuntary commitment was not based on things back to 2022 for sure. I was anticipating perhaps November and December because if she was involuntarily committed, there has to be some exigent circumstances shown for that to take place. So those exigent circumstances would have occurred contemporaneously with the filing or very close thereto.
Well, and I can presume that, right? Because now, in fact, what I had thought would happen has in fact happened. I thought you would say 1 or 2 months, and the other side would say 1 or more years. So in order to effectuate your agreement, look, folks, let's look at this thing for whatever it is, and if something exists, and I'm not saying it does or doesn't, but if it's there, and I don't know that one side or the other can or can't prove it, but it's like anything else, right? It's like cholesterol or diabetes. Nothing happens overnight. So knowing that records should be produced before December, what amount of time, and forget specifics at this point, because you really hard to pinpoint when something could or couldn't happen, and it's really hard to prove a negative. So let me now ask this question, Ms. Figueroa. How much time do you believe would be reasonable and necessary for the request?
Your Honor, at this time, I would ask for 12 months before, and let me tell you why. Once we get those records, if we have to come back and ask for an earlier time, we're happy to do that. But it is a compromise. I don't think 1 or 2 months is sufficient. But I would say 12 months should be sufficient.
Response?
Yes, Your Honor. So first of all, Dr. Ching had my client involuntarily committed based on something, which tells me he already had the information available to have her committed. So I think that this is an overreach and an overgrab. Obviously, he wasn't able to have her involuntarily committed upon hyperbole or you know guesstimation of what was going on. He absolutely had to have it based on some kind of substantial facts. Now, therefore,
Let me ask you this, Ms. Hicks, because it sounds like the information that Ms. Figueroa is requesting on behalf of Dr. Ching actually would prove your case. Wouldn't your client want that same information?
well, and I'm sorry, maybe I don't understand your question, Your Honor, with regard to would I want that same information?
If what you're saying is true, and I don't know that it is, but if what you're saying is true, then the information requested by Dr. Ching would prove your case.
Right. Well, it's our position
And
that
if it
Dr.
proves your case, you're going to have to produce those documents in court anyways.
Right. And I understand that, Your Honor. What I'm saying is that our pleadings directly relate and allege that this commitment was improper. Therefore, the time period should be narrowly tailored to the facts that he had within his knowledge to have that involuntary commitment executed, which means that was not, they're not going to do an involuntary commitment based on facts or things that were the situation 12 months prior. That was done in December of 2024. It has to be based on things currently taking place or currently those facts that were currently in existence at that time. So to go back and say, oh, well, she was, on antidepressants, being on antidepressants does not lead to an involuntary commitment, rather. So again, I'm just asking, and it seems a little, the thing is Dr. Ching he had the involuntary commitment done. So therefore he had in his possession whatever facts and evidence he needed to allege to get that done. So regardless, I don't think it's necessary, but in an effort to just, give them and to be, to get past this discovery issue, I was expecting Ms. Figueroa to say October to December, because very clearly, if there was an involuntary commitment, the facts that support that were going to happen either contemporaneously with the commitment or they're very close there too. There has to be shown an immediate danger to oneself or to others. And so an immediate danger can't be based on something 12 months prior.
Right. I've heard the argument on that. Now to the the steep waters that Dr. Ching had waddled into. And that is the court was taking notes and hearing the agreement, and the first thing that I wrote was mental health care providers, and I was wanting to be very specific because there's so many ways that could be classified. And sure enough, I knew it. There is a difference of opinion as to whether a primary care physician or a mental health professional, and so on and so forth. So crystallize what agreement, if any, you all have as to what providers this agreement would cover.
Your Honor, again, on page 2 of my motion, I specifically sought and request respondents' medical, psychological, and psychiatric treatment records, including records sufficient to identify treating providers. That's on the bottom of page 2, very specific in my motion.
Response, if any?
Yes, and again, we are in agreement, and will, I believe in our discovery responses we did, but with this, we can make part of the order that we will disclose her mental health providers during the time period of whatever the court orders. That shouldn't be an issue. And Dr. Ching is aware of who her healthcare providers were anyway, because they share insurance, and the services were applied for on the insurance. So there is a record.
But to answer the court's question, we are seeking the medical, psychological, and psychiatric treatment of the respondent.
That is the request to compel the HIPAA authorization. Talk to the court on this deposition and the request to quash.
Yes, Your Honor. Very simply, Dr. Ching found himself having to file a motion to quash his deposition, having not conferred prior to the time that it was actually noticed. Regardless, Your Honor, the notice provides that the deposition would be in Bexar County, Texas. The case is pending in Webb County, Texas. I certainly offered several dates to Ms. Hicks after receiving the same date that I received her deposition notice, and requesting that the deposition of Dr. Ching be in Laredo, Webb County, Texas, at my office. In our conversation today, the discussion was that she would take, my request is that the deposition be in Laredo, Webb County, Texas, at my office. And the next day I would travel to Bexar County to take the deposition of Ms. Delgado in the office of Ms. Hicks.
Response.
Yes, Your Honor. So first of all, I sent a letter November 19th of 2025 to opposing counsel attempting to confer on dates before noticing it. I got no response, and so I went ahead and did that. With regard to taking my client's deposition, there has been no notice of intent to take her deposition. So that part I don't think is proper for us to be arguing today. I noticed Dr. Ching properly. It is within the mileage requirement in the Texas Rules of Civil Procedure. And there is no, legal objection. I'm entitled to take his deposition. And I've now been waiting since November to have, this taken care of. And we're just eating down on our time with regard to when we're set for trial. So respectfully, I'm requesting that as there, there is no, if Ms. Figueroa wants to notice my client to take her deposition and wants her to travel, it's within the mileage requirement, and wants us to travel to Laredo, that is her right, just as it is my right to do it here. And so, without there being any legal grounds to quash my properly filed and noticed Notice of intention to take oral deposition. I'm requesting that the court strike their motion to quash and to order that he be present, and then opposing counsel and I can confer on dates, and I can find a date that is available for her.
Ms. Figueroa, let me ask you this, because it sounds like what you're saying is, and if this isn't what you're saying, crystallize it, because this is what I heard, that it's not the deposition itself that your client objects to, it's the location.
It was the location and the time, and I'm not going to do to Ms. Hicks what she did to me, which is to just notice her client's deposition without having a discussion about the date and the time. So that's why I talked to her about it today, and that's why.
Yeah, let me ask you all this, Ms. Figueroa, Ms. Hicks. So it's 7:14, and the court does these hearings hybrid, in person and by Zoom, depending on the availability of persons, and lawyers sometimes show up in court, sometimes on video conference. Same thing for parties and witnesses, but at least I think for most of the respondents and partially for some of the petitioners, you all have appeared by Zoom. Why shouldn't the court just order all the positions be on Zoom? If you all can't come to court, why should you all come to each other's places and not the court?
Your Honor, I object to that because I like to show the witness exhibits, and it's hard. Frankly, for me, it's hard to do that. I'm a dinosaur, and it's hard to show exhibits that way.
Are you with the same opinion or a different opinion, Ms. Hicks?
I'm not necessarily of the same opinion, but because, like I said, because I had attempted to confer, and then when we had spoken about it, Ms. Figueroa had expressed her objection. I was simply trying to do it how she wanted to do it, and then I'm still stuck here without a deposition.
Actually, no, Your Honor. I have said yes to a deposition. The objection, which is a valid legal objection, despite opposing counsel's comments, I certainly did object to the time and the location. This case is pending in Webb County. Dr. Ching's deposition should be taken here, and to accommodate the respondent and her counsel, I'm willing to go to San Antonio to take that deposition.
All right. Anything else from any side?
No, Your Honor, it's 7:14.
Yeah. So, Mr. Ching, Ms. Delgado, so there's two pending things before the court. Let me do this with regard to the first. The court is going to approve the agreement and then fill in the blanks on things that aren't agreed to. So as to the medical documents for Ms. Delgado, the court will order that HIPAA authorization to the medical professional psychologist and psychiatrist as listed on the bottom of page 2. There is to be a confidentiality order. The court is going to do two more things. The time period will be from January 2024 to the present. However, as part of the confidentiality order, there is to be a disclosure from the recipient as to any documents that are either not, I don't want to say not responsive, but not relevant to these proceedings. And then there's going to be a written stipulation that those documents have been destroyed and not shared. So just get rid of anything that isn't relevant, and then just disclose it to the other side. That way the other side knows exactly what, when, where.
And just to be clear, Your Honor, we're talking about mental health providers, correct?
So this is why I was very specific, and that's why I was asking for specificity. So
Well, that's what we had agreed to.
It's for medical providers, psychologists, and psychiatrists. So healthcare providers.
So her gynecologist then. That's what we had agreed to, was mental health care providers, so that it would accept out any primary care physician, anything that was not related to mental health care with regard to her involuntary commitment.
So I would presume, Ms. Hicks, that any receipt of gynecological information would exceed the court's scope and order. However, in the event that information is inadvertently received by the other side, this is why I'm saying there's to be a disclosure that it was received and it was properly destroyed without dissemination of that information, to cover weird scenarios like the one you just provided to the court. But I don't think any, Ms. Figueroa, do you have any reason to believe that that information would be relevant or necessary?
Not only would I not believe that, I would not do that.
So, and there will be a disclosure of any information that is received, not relevant, and destroyed and not disseminated. That should
I'll include that, Your Honor.
All sides in a good position. Regarding the deposition, you're in Webb County. You were in Bear, but I understand Ms. Delgado lives in Bear. I think if Mr. Ching lives in Webb and Ms. Delgado lives in Bear, just send 3, 4, 5 dates that you're available. Take Mr. Ching's deposition in Webb. Take Ms. Delgado's deposition in Bear, if that's what you can agree to. But so what I don't want to hear at our next go around is that 5 dates were provided and every single date was objected to. So just pick dates, confer dates, scratch off dates that work. And if the last date is really hard, then force it in so you can take those depositions.
Judge, and I have had no notice of intention to take her deposition, and that's not part of the motion here today. So I just want to be clear. The only thing before the court is with regard to his deposition.
What I don't want, Ms. Hicks, is I don't want, if Ms. Figueroa has already agreed to take Ms. Delgado's deposition in Bear, I don't want her to notice a deposition in Webb and then be here if it's already agreed to take that deposition in Bear. You see what I'm trying to do?
I do. Yeah, I do.
I'm trying to get you both much further than where you're at right now, than just be it a free-for-all and you're going to find yourself back in court. So I do think it's reasonable that if one party lives in Webb, even though the case is in Webb, it'd be taken in Webb, and the other person lives in Bear, but there's an agreement to take that deposition in Bear, then I find that to be reasonable. And you avoid coming back and telling the court it should all be in Webb or all be in Bear. Go take the depositions where folks live, and that'll put them, I think, in a better position.
Okay.
Exchange 5 deposition dates, pick one, and take it from there. Anything else on this case, Ms. Figueroa?
Nothing further, Your Honor. I do thank you, and I appreciate you taking the time to hear us.
Anything else on this case, Ms. Hicks?
No, Your Honor.
Ms. Delgado, do you have any questions for the court?
No, Your Honor.
Mr. Ching, do you have any questions?
No, Judge.
All right, keep in contact both with your mutual and respective lawyers. They're going to be sharing some dates and information with you. And obviously, Ms. Figueroa, this confidentiality notice applies to all of each of the parties' agents and so
Correct.
forth.
Correct.
I wish you both well, Mr. Ching, Ms. Delgado, Ms. Hicks, Ms. Figueroa. Good to see you both. Have a
Thank
good
you,
night.
Thank you, Judge. Be safe, everybody.